In many divorce cases, one spouse has been unfaithful to the other and committed adultery or other acts of illicit sexual behavior. Illicit sexual behavior is defined in North Carolina law as acts of sexual or deviant sexual intercourse, deviant sexual acts, or sexual acts as defined in North Carolina criminal law, voluntarily engaged in by a spouse with someone other than the other spouse. The specific sexual acts defined in the criminal law include cunnilingus, fellatio, analingus, or anal intercourse, and also include the penetration, however slight, by any object into the genital or anal opening of another person's body, except for accepted medical purposes. In North Carolina, if a supporting spouse has committed an act of illicit sexual behavior, the dependent spouse is entitled to alimony. However, if the dependent spouse has committed an act of illicit sexual behavior, he or she will not be entitled to receive alimony from the supporting spouse. If both spouses have committed acts of illicit sexual behavior during the marriage prior to a separation, then a judge must decide if a dependent spouse is entitled to receive alimony and the supporting spouse must pay. In order to assert a claim for alimony based on illicit sexual behavior or adultery committed by your spouse, you will need to obtain admissible evidence that the conduct was committed. Adultery or illicit sexual behavior is usually proved by circumstantial evidence and only very infrequently by direct evidence of the adulterous acts. Under the doctrine of inclination and opportunity, adultery is presumed if it can be shown that the parties had an adulterous disposition or inclination to commit adulterous acts, and that there was opportunity to satisfy their mutual adulterous inclinations. Circumstantial evidence of illicit sexual behavior is typically obtained by a private investigator who conducts a surveillance of the spouse who is acting suspiciously. Evidence of inclination can be satisfied by observations of hugging, kissing, or other intimate behavior. Other circumstantial evidence of inclination may also exist, such as emails or text messages with sexual content or expressions of love, photographs, or records of gifts or expenditures of money on the third party. In addition to the evidence of inclination, there must also be evidence that the spouse and a third party spend time alone together in a location where there is opportunity for sexual relations to have occurred, such as a hotel or an empty beach house. If you suspect your spouse of being sexually involved with another person, you should contact a lawyer about the necessary steps to obtain admissible evidence of the conduct and what to do to protect your legal rights.